to read the act or you don't want to read the act?
I will read the act now.
Chaliye.
I'll start with section 1. But first of all, let me say this one. I would just state this thing that with the empathy, all honest tenure, if I'm still alive, I would have completed 50 years of practice in this honorable court.
Can you please read? No,
Yes.
let's not do that.
Let me say.
This is public time.
When I saw this act,
Let's read it. When you saw it, we're not interested.
well, see the section 2 thereof.
Please read the whole act.
I read it. Whereas Article 191, I'm reading the preamble. 191 of the Constitution provides that subject to the Constitution and law, the Supreme Court may make rules regulating the practice and procedure of the Supreme Court. Now, at present, there are the 1980 rules which govern the procedure here in the Supreme Court. Before that, there were the 1956 rules. The 1980 rules were on account of a judgment which came in 1979.
Ajay Saab, please focus.
Okay, I'm focusing myself.
We know the 1980 rules.
Background.
No, please don't. We don't. The country expects 57,000 cases to be decided. We would love to hear you, but let's focus on your petition. Now you have started reading, you started giving the history of 1980 rules. We know that. If you'll ask a question, please answer that, but proceed with your arguments.
I have said about this 1980 rules for the simple reason that if I read now section 2, it says...
Please continue, don't jump to section 2.
Right. And whereas Article 10A is of the Constitution, mandated right to fair trial and due process. Article 4 of the Constitution guarantees treatment in accordance with law. Article 25 of the Constitution prohibits discriminatory treatment, and right of appeal is a universal fundamental principle of jurisprudence, and Islam guarantees right of appeal. Therefore, pursuant of Article 175(2), read with Article 191 of the Constitution, this law is being enacted. The court will see that there is no mention of item 55 of the federal legislative list as far as this preamble is concerned. It is silent. Because that is the basic, what can the parliament do? Parliament is not omnipotent. It has to go according to certain constitutional limitations. That principle of old principle that the parliament is supreme means that they are omnipotent, led by Dicey and influenced by Blackstone and Co. So we all agree that Parliament has limitations.
This law doesn't say that. Don't insert words which are not written there. Law doesn't say Parliament is omnipotent. Just restrict yourself to the act which you have challenged.
When I say this thing, that this very preamble does not mention.
It's noted. Read it on.
Okay. And whereas it is expedient to make a law providing for certain practice and procedures of the Supreme Court. It is hereby enacted as follows. This act shall be called the Supreme Court Practice and Procedures Act 2023, and it shall come into force at once. Constitution of benches, that the crucial question which arose. Every cause, appeal, or matter before the Supreme Court shall be heard and disposed of by a bench constituted by the committee comprising the Chief Justice of Pakistan and two next most senior judges in order of seniority. Now, the 1980 rules, Order 11, read in this manner. Well, if you have to correlate it may be important to do
सर
that.
पहले अगर इस एक्ट को पढ़ लें हम ताकि हम
मैं
सबको
पढ़
पता
लेता
लग जाए कि
हूं.
इसमें
Okay.
क्या
Or
है
if your
क्या
lordship,
नहीं.
if
Thank you
if
very
they,
much.
Sir, which rule were you referring
if you want to continue like this, we'll go ahead. But my viewpoint is this, that this frame of these rules under Article 191 is the prerogative of the Supreme Court, sitting as a full court. When they framed the 1980 rules, the entire court sat together, and in their wisdom, together they framed the rules. This abdication or this intrusion by the Parliament into the affairs of the Supreme Court prompted me to come forward and file this petition. Because I feel that every institution must remain within its own domain.
Khwaja Sahab, I'm here on this side.
It's right here.
I'm here on this side. If you could kindly formulate your exact legal proposition. What you are suggesting is that you do not have any objection to the untrammeled, unaccountable powers in one office. Is that your question?
My contention is this:
Are you supporting what has happened in the past?
I am supporting what happened in 1980, and I'm
So what
supporting.
is your legal
My
proposition?
legal proposition is this: that this power of forming the benches, etc., is the domain of the Supreme Court itself.
If this is your
Khwaja
proposition.
Sahab, I think you
If-
should read
if
the
this-
law first, Khwaja
if this
Sahab,
is-
and then formulate
let us-
the points.
let us
Act तो
first
पढ़ लें,
formulate-
Act पढ़ लीजिए,
पहले
उसके
Act
बाद
पढ़
में
लें,
फिर एक-एक को
Then
देखें.
I-
It is only
then
2 pages
I-
Act.
then
It is only.
let me follow the Chief Justice.
Khwaja Sahab,
Let me read the law, and then we make my submission.
If I may make your job easier, undoubtedly, it's sometimes very difficult and disconcerting if
I know it's very difficult to get the answer questions.
Zara sun lijiye, Hazur. If you are receiving a lot of questions from different sides, you don't even know who is asking the questions. If one of your associates jots the questions down, please don't respond to it. We let you argue it as you want to. Let me just finish. You read the act. You just point out, either you say this entire act is ultra vires a constitution, that's one contention. If there are certain particular portions of the act which you think are ultra vires a constitution, please, as you're arguing, point that, formulate the contention and move ahead. You don't need to respond to every query immediately. It will make your life very difficult because you won't even know where the question is coming from. One of your associates can take, and when you're done with your arguments, you can absorb the questions and respond. We will give you time to respond to the queries. ठीक है? तो आप please continue with the act.
Just can you take down the points and so that you can answer them. Second part of this section 2, soon after commencement of this act, the committee constituted under subsection 1 shall hold its first meeting to determine its procedure, including the holding meetings and constitution of benches, provided that till such time the procedure is determined under this subsection, the meeting of the committee for the purposes of subsection 1 shall be convened by the Chief Justice or other 2 members of the committee as the case may be. The decisions of the committee shall be by majority. Now, this is what the Parliament has enacted. And the provision which they have used is Article 191. At this stage, I would simply say this thing, that when myself and Imtiaz will be answering your question and formulating, we would certainly refer to item 55 of the Federal Legislative List, which spells out whether the Parliament can make enactments relating to Supreme Court. If I may read 55 at this stage, it may be.
Argue as you want.
Well, all right, I'm just saying that your lordship should note item 55 of the Federal Legislative List.
Let's read it together. You wanted to read it. Let's read it.
We will read it together.
Khwaja Sahab, I think before going, I'm here, left side, your right side. before going to this entry, if you want, you may read Article 191 of the Constitution.
191.
What is said?
191 also.
Who made
In fact, I can start with Article 70, go on to 142, and then read 191 and go up to 55. Article 70 gives the power of legislation, and it is to the effect legislative procedure. And what it says is, a bill with respect to any matter in the federal legislative list may originate. I will skip that. I'll go straight on to subclause 4 of Article 70. In this article and the succeeding provisions of the Constitution, federal legislative list means the federal legislative list in the 4th schedule, sir. Then there is Article 141. Subject to the Constitution, Majlis and Shura Parliament may make laws, including the laws having extraterritorial operation for the whole or any part of Pakistan, and the Provincial Assembly may make laws for the province or any part thereof. 142. Subject to the Constitution, Majlis and Shura shall have exclusive powers to make laws with respect to any matter in the federal legislative list. Then I take your lordship to 191, which is to the effect subject to the Constitution. Again, subject to the Constitution and law. It is the Supreme Court. The Supreme Court may make rules regulating the practice and procedure of the court. The crucial words here are that the power has been given to the Supreme Court to regulate its practice and procedure.
these powers are under the Constitution? Your right side. These powers are under the Constitution and the law.
Constitution and the law. I'll say also. I'll come to that also, because when I read 55, then it will be clearer.
Khaizab, if I may request my learned brother, I know it's very disconcerting, so many judges asking questions. So we will let you argue in your own way, and we will ask you questions. You don't respond, you just note it. And because then I know your chain of thought will...
Point is noted.
Chain of thought we don't want to break.
Constitution and law. Point is noted. Constitution and law. Point is noted of my lord. Jurisdiction and powers of all courts can be subject to the power of the Parliament under 142 and 74.
Khaizab, just read it as is. Don't interpret it. Then you can interpret it.
Okay, I'll go along with it. Jurisdiction and powers of all courts except the Supreme Court with respect to any of the matters in this list, and to such extent as is expressly authorized by or under the Constitution.
Supreme Court Practice and Procedure Act 2000.
That you will not legislate regarding Supreme Court, but you can give them, enlarge their powers, or supplement them. What will the meaning of that? That will be explained by my associates with case law.
Mr. Khwaja Sahab, the two crucial expressions are jurisdiction and powers. And the law that you are challenging does not concern both of these expressions.
Yes, sir. Point noted. Jurisdiction and power. Jurisdiction and power. Well, I'll answer that.
आप नोट कर लें ये सवाल.
सवाल आपका मैंने सुन लिया जी. Please note this down, that we have to have jurisdiction and powers both. We'll explain both. It is plain board. This is what the Constitution says. Now, this is regarding the benches, section 2. In one word, I would say this, that this power of 191 gives the power to the Supreme Court itself to regulate its procedure, as has been done in the past, as has been held in a number of cases which we bring before your lordship. Those cases are well known.
Now I just ask a question, you can note it.
Ji.
Are you suggesting that that even the rules of 1980 are ultra vires the constitution? Please let me finish. Because the power vests in the Supreme Court as all the judges of the Supreme Court. That could be one reading of your argument. So you are saying that section 2 is the ultra vires of the constitution, which gave power to 3 persons. Order 11 of the rules is ultra vires because it gave power to 1 person. Is that your proposition?
No, madam. My proposition is very straightforward. As far as the 1980 rules were concerned, they were made by a full court, which was at that time. The entire historical perspective has been given. My proposition is slightly different. These were under 191. It is the function of the Supreme Court itself to regulate it.
Okay.
See, Maryam sir, 184.3 is not the only part.
Raja Sahab, you can later answer my question. So what you are saying is that the expression subject to the constitution and law, this becomes redundant? That is the question. That is what you are interpreting it.
I'll answer that. We'll
And
answer
the
we'll
law
answer that.
is enacted by the Parliament.
We noted, we'll answer this thing. But my basic question, why I came before your lordship, is that the functions which are there with the Supreme Court, there should not have been there with the Parliament. Because that institution that has its own, today they say that how you are going to have the benches, tomorrow they will say that such and such bench will have this case, such and such bench will have that case.
Please,
They can say that also.
please let's not go into
Well,
what they may
I-
or may not do.
All right. Why I'm saying is this,
No, no,
that
no,
if I give them
no.
unbridled power,
No.
then anything can happen.
Raja Saab, it pertains to your attack on a particular piece of legislation.
But I will
Please
say this thing.
no. What Parliament decides to do future, you can bring another petition, we can look at it then. Restrict yourself to your case. Please proceed.
I will say this thing then, Maryam, that this clause 2 is beyond the powers of the Parliament. Three, and when I'm arguing, Maryam, my associate will explain that 184.3 is not the only thing which is regulated by the Supreme Court rules. If your lordship would have the 1980 Supreme Court rules in front of you, there are the different types of jurisdiction which are available to you.
Shall we finish with the act quickly?
Or can I finish with the act, Maryam? Exercise of original jurisdiction of the Supreme Court. Any matter invoking exercise of original jurisdiction under Clause 3 of Article 184 of the Constitution shall be first placed before the committee constituted under Section 2 for examination, and if the committee is of the view that a question of public importance with reference to enforcement of any of the fundamental rights conferred by Section 1 of Part 2 of the Constitution is involved, it shall constitute a bench comprising not less than 3 judges of the Supreme Court of Pakistan, which may also include the members of the committee for adjudication of the matter. I will simply say on this thing that this is
Raja Saab, sir, on your right side, but not
Ji.
as much right as previously. Yeah,
yes, Maryam.
over here. Question, so your associates can note this. This power that Section 3 purports to confer on the committee with regard to examine the question and therefore act as a gateway perhaps, is this a power or is this a judicial power or is this an administrative administrative / statutory power.
My,
Because 183 is ultimately a judicial power. Because then it seems to me that the latter part of this section says it shall constitute a bench. That seems to imply that the power exercised by the committee is not a judicial power, but an administrative power. So can Parliament whittle down? This is the question, please note.
yes, it's
Whittle
judicial,
down
and
the
in
question,
fact, that is
whittle down power.
that will be exactly my
Please,
proposition.
please, here is lordship.
सवाल तो सुन ले. Can the Parliament whittle down the judicial power under 184(3) by providing that this committee will act as a gateway and block out in exercise of administrative power anything that the committee feels, 3 judges, not the whole of the Supreme Court, but 3 judges, senior most respectable judges, but in the end just 3 judges, block out any case that they, in exercise of administrative power, they will deprive the Supreme Court from exercising judicial power. So you kindly note the question and you address it at an
And I will go even further than that.
And also a supplementary question
Yeah.
connected to this. Earlier, the justice solely had this power. So there was a likelihood that the outcome of the cases could also have been influenced by the constitution of the bench. So that eroded the independence of judiciary. If this argument is accepted, then the earlier traditional model would be acceptable to you, that one person can actually control the outcomes of the cases by constitution of benches, and this probably was the mischief that the Parliament wanted to address.
I would,
If
I
I may add, there is a judgment of this court and the judicial pronouncement on that as to what procedure would be followed by the Chief Justice to invoke jurisdiction of this court under Article 183. And it says where a bench, 3-member bench, 2-member bench, but a bench comes to the conclusion that there is a matter of public importance affecting fundamental rights, they may recommend to the Honorable Chief Justice that a bench be constituted. And the Honorable Chief Justice, after seeing the reasons that the bench has assigned for recommending, he may or may not, but at least he would record reasons why he thinks he disagrees with the recommendations, or thereafter he can proceed. And so there is a judicial pronouncement on that already in place.
in fact,
Sir, I'm sorry, since
may I say,
Honorable Chief Justice has said that we can only ask questions and not for you to respond immediately. So let me, with all due respect, ask a supplemental to what the supplemental put to you by my learned brother, colleague Justice Atar Minallah. It seems to me that the power to constitute a bench, which is the subject matter of Section 2, constituting a bench does not block the exercise of judicial power. It simply determines which is the bench that is to exercise judicial power.
Yeah.
But my question to you is that Section 3 seems to go beyond that. Section 3 is separate from Section 2. It actually blocks, it confers on the 3-member committee exercising administrative powers to actually block the exercise of judicial powers. It's not a question of constitution of benches. They can say, sorry, out, nothing further, matter ends. The question is this, so this is not a question of composition of benches. That is power universally on them in terms of Section 2. The question here, it seems to me, is the very blocking of the judicial power itself. Can Parliament do that? Question is maybe noted.
and
You don't have to answer.
No, I'm not
Please
answering.
carry on.
I'm not answering.
The Honorable
Your-
Chief Justice
your-
said you
your-
carry on with your
Your
submissions.
Honor
Just
has
note the
said
question.
this thing. I will add one thing to it. It also deprives me of my right, which they have said that they are passing this thing under Article 10A of the Constitution. Here, if Section 3 is there, I'm being condemned. I'm not being heard.
Who is
The
that?
party is not being
Please,
heard.
who
It-
is,
it is-
when you're using the word I, who is the I here?
litigant, the litigant. Because
एक second, sir. Tahammul. The litigant, that leads me to another question. Your petitioners, do they have an interest in the matter, or they've come purely as a matter of public interest?
I am looking at Section 3.
No, I'm not talking that. I'm not asking a question of the petitioners. Do they have an interest in any case why they brought this challenge, or they brought it in the public interest? What is the answer?
Answer to that is that it's a public interest.
You have no personal interest in the matter, you or your client.
I have no personal interest.
You
because-
meaning your client.
But let me say this thing.
No, I just want to know an answer to that.
Myself and Mr. Siddiqui, we are doing this as pro bono. We are doing it because we want to know,
I don't know who you're speaking for. Are you speaking for counsel? Are you speaking for petitioners?
I am speaking for the petitioner and I'm saying this thing that we brought this petition
Take
in
up a point
in
noted.
the interest.
You got the answer,
In
Now
the-
please proceed. I've got the answer.
Because in the interest that,
Ye-
that the law should take its course. The constitution must be upheld.
ठीक.
And I am also saying that I'm sure with such preliminary sitting there, the whole object is that, first of all, the independence of the judiciary should not be in any manner smeared by any other institution. And secondly,
Khwaja Sahab, please.
I will not,
We are not going to
I will
platitudes.
not make a political speech.
Khwaja Sahab,
I'll refrain
Khwaja
from
Sahab.
that.
Just proceed
Khwaja
with the
Sahab.
act.
Yes, sir.
Khwaja Sahab, just a confusion which you can answer later. So what you are saying is that the untrammeled, unaccountable powers of the Chief Justice exclusively to decide constitution of benches, you were satisfied with that, and that fulfilled the conditions of Article 10A. But if it is done by the Chief Justice and two senior judges, you have an objection to that. That's your
I think
proposition.
your lordship is possibly not, I've not been able to explain. Section 2 stands on its own footing, and I have objection on that. Section 3 is a totally different thing. It takes away the powers of this honorable court. Why
it does not?
instead of
Khwaja Sahab,
Section 3 is a totally different thing. It takes away the powers of this honorable court. Why
it does not?
instead of
Khwaja Sahab,
Is
Khwaja
it
Sahab,
your
let us
argument?
clarify.
Is it your
It
argument
takes
that
away the
section 3 affects the judicial powers of this court?
Yes, sir.
Curtails judicial powers of this court because this court means the Chief Justice and all
the
judges. So it confines that power to 3 judges and not to the judges of the Supreme Court.
That's not fine.
I've been trying.
2 and 3 have to be read independently and separate.
Now, please,
And that too an exercise of administrative powers.
Yes, sir.
I'm trying to make your life easy, but if you don't want it to be made easy, that's fine by me. Please don't interrupt. I've requested you, please keep noting the queries. Naturally, you have a chain of thought, you have submissions. We don't want you to get, I can appreciate your position. So many judges, so many questions, which one do you answer? And then your argument is lost sight of and you go somewhere else. So please persevere with your thing. Keep noting the questions and you can address them. So I'm trying to make your life easy, unless you don't want it to be made easy. So proceed with your case. Note the question, respond to it later.
In fact, to
And,
be very, very
excuse
honest,
me.
I welcome this interruption.
Can I ask you a question? Can I ask,
All right.
please? What about the office of the Chief Justice after passing of this act? Don't you think that the office of the Chief Justice would become redundant? Because he would be left with no powers then.
We noted this down, and in fact, I would say that the Chief Justice powers will be whittled down, as if this law goes through, the powers will be whittled down, but we'll explain it in something. And this has been held in many places, that the Chief Justice has the power to form the benches, is the rooster, and I can go back years and years when a chain of judgments have come in, and the latest one is, of course, 2000.
ऐसा फिर आप आंसर करने
All right,
बैठ गए।
I will continue. Let me
आप नोट
continue.
कर लें या बाद में
Okay,
कर लें।
let me continue.
Mr. Khwaja, I will
Then-
add.
then is a
Mr.
question-
Mr. Khwaja,
Yes, sir.
right side.
Right side.
I will add to it. Whether the power of the Supreme Court has been curtailed or the power of the Chief Justice has been.
I
This
think
is the moot question.
the answer to that is that it's been noted, sir. It's noted, and I will only say this thing, that Supreme Court, what is Supreme Court? Supreme Court is
Wajah sahab,
Chief
Wajah
Justice
sahab,
and
if
so
you-
many other judges.
Wajah will be sitting here till 12 o'clock.
I know that, sir.
So आप जरा
let's
अपना argument करें। अभी तो हम section
let's
3
do
पे
it.
पहुंचे।
Let me, on section 3, I will only say this thing, that this certainly is, the parliament has taken away the power, not only from the Supreme Court and the judges, but also it has condemned me unheard and violated the provisions of Article 10A, which provides for a fair trial. Because I will file a petition, I've not even heard, and 3 judges or 2 judges, they will decide on an administrative side, and I'll be out. So the question of 184(3) will become totally redundant. This is my point.
जी, आगे बढ़ते हैं।
Therefore, to that
Let's
extent,
put-
section 3 is. Then next is 4, interpretation of the Constitution. In the matters where interpretation of the constitutional provision is involved, committee shall constitute a bench comprising not less than 5 judges of the Supreme Court. Well, I will.
Do you object for say I object to this provision or you endorse it?
I will say this, sir, that in the matters of interpretation of the Constitution, when you are, all the judges are competent to interpret the Constitution. By limiting it to 5 or limiting it to 3 or make, why not 7,
Yes, sir,
why not
please,
6?
please,
I
No, you're
object to
arguing-
this thing, that this is a limitation.
No, it's not a limitation. It says not less than. It could be a full court like the present court. So are you just say, is this ultra vires the Constitution section 4? Say something, we should note it.
On this, I will only say this thing, that putting a clause that the bench should be not less than 5, that possibly is expressing, shall I say, not confidence in less than 5 judges.
ठीक, well noted.
Because this is very strange, because all judges are equal. Your lordship is the first amongst the equal, but every other judge of the Supreme Court has the same powers and the same acumen. So by saying this thing, it's not less than
आगे
5.
बढ़ें, आगे
Wajah Sahab,
बढ़ते हैं।
as I
Then there's a
understand,
question of appeal, and which is a very relevant point.
Wajah Sahab, as I understand your earlier proposition, you are satisfied that the Chief Justice in the previous model, being the master of the roster, had untrammeled power to constitute a bench of 3 members, and you were satisfied with that.
I have
But if a
I have
committee-
noted this thing.
Yes.
Your lordship did not, sir, I would not be able to explain. It's my shortcoming.
Explain later.
On the question of benches, I have stated with this thing that this power should be exercised by the full court, not by the parliament. About how the benches are to be.
आगे बढ़ते हैं।
I will dwell on that.
In a nutshell, you are suggesting that the powers as master of the roster in the Chief Justice were also unconstitutional.
No, sir.
This is your
No, sir, I'm saying this thing that under 1980 rules, that power had been given. If all of you sitting together feel that under 191 that it should be changed, then it is your function. It is not the function of the parliament.
ठीक है, now let's proceed. We'll ask.
I'll argue on that.
लेकिन अगर
That is
आप
the point which needs
Yes, sir.
consideration. Side is appeal. Yes, Mr.
Sir, on section 4.
Also.
If memory serves me right, section 4, what is the equivalent of section 4, is part of the Indian Constitution as an article of that Constitution. It was a part of the 1956 Constitution as an article of that Constitution. Now, question is that when the framers of the present Constitution had before them this model where this very power was conferred on the Supreme Court in the way that what in India they are called constitution benches. The question is this, that model, that aspect was not accepted by the framers of the present Constitution because they had a model both from India and from Pakistan itself. So the question is this, if that was not accepted, does this not require constitutional amendments? Can Parliament do something which the framers of the Constitution deliberately seem to have left out, despite the earlier models? Can Parliament then, in exercise of sub-constitutional jurisdiction, namely legislative competence, do something that was earlier part of the Constitution? This is the question, please note.
Yeah, it's noted, sir, and I may add on to this.
साहब मैं एक सवाल पूछ लूं आपसे, अगर उसी में डाल दें आप लिस्ट में अपनी।
जी
मैं इधर हूँ जी।
जी सर।
मैं बस सिर्फ सिंपल सा आपकी जो समझ आई है मुझे आपकी कि ये सारा कानून अगर यही सारा फुल कोर्ट बैठ के बना ले तो सब ठीक है।
नहीं सर,
सुन लीजिए, सवाल तो सुन लें।
जी जी।
कि 17 जज बैठ के ये सब कुछ बना ले तो ठीक है, पार्लियामेंट ये सारी चीज बना दे तो गलत। ये आपकी बहस है ना सारी?
नहीं नहीं सर, ऐसे नहीं है।
आपने यही कहा, आपने कहा ये सारी चीजें करो, लेकिन
नहीं सर ऐसे नहीं,
सुप्रीम कोर्ट
नहीं ऐसे नहीं।
चलिए बस नोट कर लीजिए।
मैं नोट कर लिया, जब सुप्रीम कोर्ट
आप जवाब ना दीजिए ना, बाद में
मैं बाद में जवाब देता हूं,
ठीक है, अदरवाइज तो आपकी मुश्किल काम हो
नहीं, मैं I'm quite I have a very
नहीं, आगे बढ़ते,
I have worked with all of you sir,
आगे बढ़िए।
I have no problem.
हजूर आगे बढ़िए, आगे बढ़िए।
If I may,
problem नहीं, I understand what Shah Saab is suggesting and